Good day, everybody. Welcome back to another video on the YouTube channel for the 0%. Be sure to check it out on Amazon.com, the 0%, to grab the book. Working on producing an audiobook for it as well. I am not going to be the one recording the voiceover. That's a lot of work. I'm actually going to work with a producer to do that for us. And it should be available in the Audible Play Store. Today was Saturday, or still is Saturday, Eastern Standard Time. We had a Saturday Zoom class for all of those that are a part of the Patreon community, the 0%. And actually had some issues with recording everything as far as storage. So what I'm going to do is go over the same information and make sure that's available to them. Some of that information will be available to you, the public, here on YouTube, Instagram, and TikTok. I have with me my liaison here, Isaiah. Some of you have already spoken with him with consultations. He's been wonderful to me. He's helping me with producing and instigating or constructing all of the injunctions for your state, including filing that information with the clerk of court, the attorney generals, the governors, the chief justice, and some of those county officials as well. Some of you have experienced receiving traffic citations and violations, and so instituting a case injunction is imperative as well. So welcome, Isaiah. Thanks for joining me for this little segment. We're going to go ahead and get started with some of the questions that we have received from our members. How you doing today?
I'm doing well. I'm ready to get into it.
Likewise. Today was a good class. Um, a lot of times I go over information where they're not ready for it. And so they're just kind of silent, just looking at everything, and they'll go back and process it. So a couple of questions came in over this past week. One, if you guys notice inside of the freshman course, there's an introduction video, and it breaks down express trust and what it is. And I started talking about what's called domestic asset protection trust. And there are 17 discretionary trust states that allow you to, or which is considered to be the best states to do your trust in for asset protection. Now, there is domestic asset protection trust, and there's also foreign asset protection trust. I usually have you guys start the process with the foreign side of it, because that is going to give you ultimate immunity for zero tax liability, to have all of your property inside of that particular type of trust and avoid taxation. It's just like when you have a whole life insurance policy where the entire vehicle is a tax deferred vehicle. So you can take it a step further by implementing an express trust. The express trust is the oldest form of trust. It is nowhere or no way, shape, or form identified as a domestic trust, as long as you have a legitimate foreign trustee who has the right to administrate and make substantial decisions within the trust. There are other ways that we go about that, so that way you feel that your entire trust property is not in the hands of that particular person. You still want to be in control. The motto is own everything, or let the trust own everything, but you control it. That's how it works. So looking down, I'm going to give you guys those 17 states that you can also record your trust after you have done it in your personal home state. So it's Alaska, Delaware, Hawaii, Michigan, Mississippi, Missouri, Nevada, New Hampshire, Ohio, Oklahoma, Rhode Island, South Dakota, and we've talked about South Dakota before, Tennessee, Utah, Utah, Virginia, West Virginia, and Wyoming. These are the 17 states that will allow you to record your declaration of trust or certificates of trust without actually having real property attached. No legal descriptions, no parcel numbers, no site addresses. You can just record it. So let's say I set my thing up here within California, which does require me to have some type of property to record the trust. Now, lawfully, the Constitution says that I can start a trust whether it has real property or personal property. And we're always starting off with personal property, such as the authenticated birth certificate. But we know that they are providing roadblocks with their gatekeepers, the deputy clerks, and they're telling us that we cannot do that unless we have a house attached. So we find a house, whether it's our house or we use a certain percentage in someone else's property to get it done by way of gift and issuing trust certificate units. That's fine. I got it recorded in California. Let's say I wanted to take it a step further and take it into one of these asset protection trust states. I can do that now in one of these 17 states. Okay. So let's say we chose Ohio. I have a few private clients who have done the process with me in Ohio. So they do not need to do anything in another state. They're already there. I pulled up this example. If I go to the Summit County, Ohio document index search, and I pull up a certain document type, they're calling it trust and memorandum of trust. So that is what I would title my document when I send it in, trust and memorandum of trust. I pulled this one up, for example. This is a certificate of trust that is recorded in Summit County, Ohio. As you see, there is no site address, parcel number, or legal description. They were able to get their trust recorded in Ohio because it is one of the 17 discretionary trust states. Now, a certificate of trust is just a synopsis of what your declaration of trust is. It's just a synopsis of what is actually the meat on the bone. You're not going to put that in the public. You keep that at home in the private. So, and I'm sure it looks very similar in all the other 16 states that you would do it something like this. Why would you do this? For example, in South Dakota, when we talked about Title 55, there is a section there where you can perform a mortgage satisfaction if your property that's recorded in, let's say, California, it's recorded in trust via a quitclaim deed, and you have a foreign trustee attached to it. The property is been in trust for at least 2 years. You now can take that into the jurisdiction of South Dakota, utilize Title 55, and have that foreign fiduciary proceed with a dismissal of a mortgage lien. One of the powers that you can exercise with express trust. You cannot do that with living trust, testamentary trust. You cannot do that with any type of domestic artificial trust. Okay. And that's exactly why those trusts exist, so that the United States court can always have control. Remove their control by operating an express trust. So that was question one that we had from our members within Patreon and in the Telegram group. And if you guys want to be a part of the Telegram group, you first have to be a member within Patreon. Go there, patreon.com/the 0%, and get signed up and enrolled and give us your Telegram username. And one of my assistants will plug you into the app so you can begin communicating with all the other members and get this thing rolling. Now let's move on to the next one. Isaiah, we're going to talk about general rules of pleading and how important that is when dealing with any type of lawsuit where someone is bringing you into the courtroom, or child support, spousal support, child protective services. They're taking your children and you don't understand why. Um, all of these different things where they're coming against your own property. And what first happens is you receive a summons of some sort, a summons or some sort of a warrant attached to, and sometimes they don't give you an actual complaint, a notarized complaint that's supposed to be attached to it, like the Constitution says. They don't do that. They just jump right to the summons. Now, that summons is serving as their complaint. In most jurisdictions, they're going to say that it's one and the same, but that it has to be a completely separate thing. Anyhow, you have to answer it. And this is one of the reasons why I choose not to hire an attorney whenever I am defending myself because someone is bringing me into court, suing me. Attorneys know, respectfully, they know legal procedure. However, they do not know lawful constitution. A lot of times they don't know constitution dating back before 1933, but they do know about the constitutions that are dealing with additional amendments that's been added to. That right there is a violation of the Constitution. They don't know that. It is a violation how? No bill of attainder or ex post facto law shall ever be applied as an obligation of contracts. The Constitution is a contract, and they're adding additional bills of attainder to that contract, and the Constitution said that it can't be. That's something that they should know. Now, they are registered with the bar, and they're considered officers of the court. So their first concern is an allegiance to the court, not you. With that being said, you're better off representing yourself, doing your own study if you have the time. Now, Rule 8, this is something that those attorneys don't do. If you look at your paperwork, the very first thing that they're supposed to do if you hired an attorney, and the very first thing that you're supposed to do is submit an affidavit of denial to that summons, warrant, or their initial complaint. Line by line, word for word, paragraph by paragraph. If I was someone who was undergoing a child support lawsuit or battle between ex-wife and everything, it didn't work out, she's going to just try to take everything from me, even though I'm going to be in the life of my child and all of that. Child support does not need to have their say in this, right? The very first thing that I'm going to do is deny the complaint that the county has against me. And we do that by following Rule 8. Now, this is Rule 8 under the Federal Rules of Civil Procedures. If I'm in court, I'm not in federal court, I'm in state court. So that means I have to find this rule that's mentioned here in federal and find it on the state level. I'm going to be doing an example for Massachusetts, the state of Massachusetts. So we go down to B, defenses of Rule 8. It says, in general, in responding to a pleading, a party must, A, state in a short and plain terms its defenses to each claim asserted against it. It says a party must. If you're going to defend yourself, you cannot skip this step. If you skip this step and wonder why they're running all over you in court, it's because you have what? Admitted to the allegations asserted against by an opposing party. You have to admit or deny. And the only way you can do that is to submit an affidavit of denial, denying line by line, word for word, paragraph by paragraph. That means you have to actually write what the complaint is saying against you and say you deny it. That's what that looks like. Okay. Now, if I were to find this section on the state level, I must go into, for example, Massachusetts. I would search Massachusetts Rules of Civil Procedures. This is a civil matter in family court. And I would go down to pleadings and motions. And here we go. Rule 8, General Rules of Pleading. Section B. See, it is identical on the state level as well as the federal level. Same thing. See what they say. B. A party shall state in short and plain terms his defenses to such claim asserted and shall admit or deny the averments upon which the adverse party relies. You must do it. Isaiah, can you read this section for me? The effect of failure to deny. This here.
Yeah, you got it. Averments in a pleading to which a responsive pleading is required, other than those as to the amount of damage, are admitted when not denied in the responsive pleading. Averments in a pleading to which no responsive pleading is required or permitted shall be taken as denied or avoided.
Plain and simple English. If you don't do it, then they're going to avoid your rights and move forward as if you agree. So you must do an affidavit of denial. If I was in Massachusetts and I would do an affidavit of denial, I would say my title would be affidavit of denial, semicolon, and I would call the complaint, whatever it's called. Let's say it's stipulation orders for judgments. I would say affidavit of denial, semicolon, stipulation of order and judgments. And then I would say where I got this from, defenses, forms of denials, B, under Civil Procedure Rule 8, General Rules of Pleading. That's how I would do it. And go line by line and say I deny each of their paragraphs and submit that as evidence to the clerk of court, the opposing attorney for child support, or whoever it is. That's the very first thing I'm going to do. The next thing I would do is a motion for discovery. Okay. Now, discovery is very, very, very important. A lot of times your case will not move past discovery if you do it right. I'll say it again. A lot of times your case will not move past discovery if you do it right. To understand how to do discovery, you need to know your Bill of Rights, or sometimes they call it Declaration of Rights. You need to know that in your constitution, in your state. You need to understand separation of powers. You need to understand that they always have you in what's called Administrative Procedures Court and all of the different sub agencies that come along with it. You must understand how the state is getting paid off of your ignorance. And like I said, all the sub agencies that come along with it. If you understand that, then you will know how to put your motion for discovery, how to draft it and submit that. Let me show you what I mean. Let's start with separation of powers. Isaiah, can you please read this first paragraph for me?
Yeah. Separation of powers is a doctrine of constitutional law under which the three branches of government, executive, legislative, and judicial, are kept separate. This is also known as a system of checks and balances because each branch is given certain powers as to check and balance the other branches.
Exactly. I remember my father having a child support case in the amount of 100,000 plus. And this was one of the things that we had brought up in our paperwork, in our motion. So we have three branches of government: executive, legislative, and judicial, and they are not to cross each other as far as benefiting from each other. The executive branch cannot pass any acts or orders where that act of order is going to bring financial enrichment to the legislative branches or the judicial branches. They're supposed to keep each other in check and not work together financially. Just know that they cannot bring each other up in money. Okay. So each branch has separate powers, and generally, each branch is not allowed to exercise the powers of the other branches. The legislative branch exercises congressional power, right? Senate, congressional. The executive branch exercises executive power, and the judicial branch exercises a judicial review. Okay. This is very important that you understand this before we move forward. Separation of powers is what I want you to look for when we move forward. Now, 1790 Massachusetts Constitution, legislative section. Section 1, the General Court, Article 1, the Department of Legislation shall be formed by two branches, the Senate and the House of Representatives. We just read that right here. It says the legislative branch exercises congressional power, Senate and congressional. We got that. Senate and House of Representatives. Each of will shall have a negative on the other. They cannot enrich each other. Okay. The legislative body shall assemble every year on the last Wednesday in May, and at such other times as they shall judge necessary, and shall dissolve and be dissolved on the day next preceding the said last Wednesday in May, and shall be styled the General Court of Massachusetts. So if you are being sued in the county for child protective services, child support, spousal support, traffic violations, or even a murder case where you were caught at the wrong place at the wrong time and they have to pin it on somebody. The one that is supposed to be suing you in Massachusetts is coming from the General Court of Massachusetts. That's the style. It would say General Court of Massachusetts versus first, middle, last name, you. If you see anything other than this, you are going to be in what's called an abuse and neglect court that has nothing to do with this Constitution. It has nothing to do with a general court. And if it has nothing to do with a general court, the jurisdiction is killed from the very beginning, if you know how to mention that and stand by it in the very beginning. Watch how they do this. I mentioned Administrative Procedures Court. It says the APA applies to both the federal executive departments and its independent agencies. Okay, so which branch, Isaiah, which branch created the APA? That would be executive, right? The executive branch created the Administrative Procedures Act. Okay, if I were to click, well, I'll come back to that. Let me go here. Now let's go down to the state level, because this is who is dealing with you when it comes to child support and all of that. Title 42, payments to states. How are these people getting paid? Going down to B right here. It says 75% of so much of such expenditures as are for the short-term training of current or prospective foster or adoptive parents or relative guardians, the members of the staff of state licensed or state approved child care institutions providing care, or state licensed or state approved child welfare agencies providing services to children receiving assistance under this part, and members of the staff of abuse and neglect courts, agency attorneys, attorneys representing children or parents, guardians ad litem, or other court-appointed special advocates representing children in proceedings of such courts. Special courts, you guys. Abuse and neglect courts is what they have you in. Why? Because you're not proven to be competent to handle your own affairs. You haven't provided a proper express trust holding the certificate of title, your authenticated birth certificate. You haven't let the clerk of court know that the express trust holds it and has a lien over it that's much higher than the state's. And until you do that, they are not going to see you as an incompetent person. They're going to always see you as someone who is a minor under legal disability. And of course, if you don't have that, you obviously won't have it for your children under a lease agreement until they're 18 years old. And so they're going to have all types of jurisdiction over you in the abuse and neglect courts jurisdiction in that realm, where in actuality, you are supposed to be in the equity or chancery court division. That's where express trust has its say. So 75% of all the monies that they collect are going to the states, the agencies, the attorneys, the representations of all of that. 75%. Now, this is the state. And guess who is the Secretary of Child Support? That is the Secretary of Health and Human Services. Okay, so we just read that the state is under Health and Human Services. If I were to go back to the executive department that gives birth to the APA and look at some of those departments, we're going to find, boom, the Health and Human Services, making approximately $1.394 trillion, a partnership with the state. They have just broken the separation of powers. Each branch has separate powers, and generally, each branch is not allowed to exercise the powers of the other branches. They have just crossed executive and legislative right here. This is an ultimate lawsuit. 75% of 1.394 trillion. That's how much they're being enriched. This is going to result in a Title 18 241 suit, Title 18 242, Title 18, and possibly 246 lawsuit that your express trust can do. Sue them all. Now, we talked about the abuse and neglect courts. They actually have an act, Public Law 106-319, strengthening abuse and neglect courts. This came about in the year 2000. This act, to improve the administrative efficiency and effectiveness of the nation's abuse and neglect courts, and for other purposes consistent with the Adoption and Safe Families Act of 1997. Here are the findings in Section 2. Guess where we're going to go? Section 8. Why is it that everything dealing with welfare and everything is always done in Section 8? Even in the U.S. Constitution, Section 8 is talking about this, how they have the power, because you give them the power, right? It says the administrative efficiency and effectiveness of the nation's abuse and neglect courts would be further strengthened by improving the quality and availability of training for judges, court personnel, agency attorneys, guardians ad litem, volunteers who participate in court-appointed special advocate, that is CASA, house in Spanish, house programs. They call it court-appointed special advocate programs, and attorneys who represent the children and the parents of children in abuse and neglect courts. Now, you don't want any part of this. So this entire section here is what you're going to quote in your motion for discovery, saying that this jurisdiction cannot have any play here with the express trust. The express trust only resides in a common law court, which in Massachusetts, they're calling it the General Court of Massachusetts. Two different jurisdictions. You have to shut down jurisdiction from its very inception. Now, your motion for discovery after these subjects that we just went over, separation of powers, Constitution, the federal government of the APA having relations with the health and human services and enriching themselves off of the 75% of this number, including Title 42, 674, going down to Section B, and the Abuse and Neglect Courts Act. You now have everything that you need to prove to the court that they are enriching themselves against you. That is discrimination of your civil rights of the Act of 1866. This is how you're going to be child support. This is how you're going to shut down child protective services, spousal support. And let me just say, when it comes to spousal support and child support, you cannot just go into this courtroom and shut down child support without actually having a plan to show to the judge how you are trying to take care of your child. You need to come up with an actual contract that you have given to the woman saying, this is what it's going to be. This is what it's going to be for medical. This is what it's going to be for education. This is what it's going to be for clothing. This is what it's going to be for food and health, shelter. And you guys plan it out. You don't have to be together in order to have a plan for the upbringing of the child. But you have to show that with the court. I kid you not, we had to do that in Ohio and in Michigan. And we had to serve the woman as well. She didn't respond to it because obviously she didn't know that she had to respond to it, but it was something that was the husband was able to bring up in court. The man brought it up in court, and guess what? The judge said, well, we're going to go off of everything that is said in this contract, and that'll be it. Because he followed the rules of the court. And as well, he shut down child support and everything else. You have to be a man of honor. You have to be a woman of honor to raise a child. So, Isaiah, that's all I got for breaking down child support and how to properly defend yourself. Anything you want to add?
Man, that was heavy. It was a lot of great information. I mean, it was just enough.
Just enough, just enough. And it will
I did
okay.
have something I did want to add in the beginning
Mm-hmm.
when you were talking about CPA,
Mm-hmm.
and it had me thinking about something we were going over a few years back. I think I remember you mentioning that when you sign the state license or marriage certificate with the state, that gives them jurisdiction over your household on the CPA being able to just come and take care of children.
Yes, it does. Indeed. The marriage license is tied within this program here, court appointed special advocate programs. And they call it CASA. And when we go back to Title 42, they mention it right here in Section B. They said it was right here, court appointed special advocates representing children in proceedings of such courts, including the parents. So this is why they have to have that marriage license. It's two corporations merging together to form one, giving them the permission to have jurisdiction over the other corporations that the two corporations created. And it's very, very sad because when you think about it, in what way would a husband and wife use their marriage license? They apply for it, they get married, they get a copy of it, it just sits at home. When
Right.
do they ever take it out and go to an office and say, oh, here's proof we're married, therefore we can do business?
Only thing that I can think of is taxes.
Not even that. They can file together a 1041 or 1040 or 1040. Just filing, they call it filing separately or filing jointly. And then
Okay.
they still never have to pull out a marriage license to go along with the tax form. Some people may say, oh, well, you need it for adopting children. Not even for that. You signing documentation or for an application to adopt children, what do they want you to do? State that you are married, you check off the box, and at the bottom, you sign under the penalty of perjury under the laws of the state. And that's enough. In case you get into any trouble, they're probably just going to go and look both of the parents' names up and say, oh, we got a marriage license on it. We have control. So you're absolutely right. The marriage license is the problem. And I will be doing a webinar on that to show how to do the marriage covenant that's attached to a trustee bond. You
Well,
must.
that was about to be my next question. I was going to say, do you have a little remedy for that?
Yeah, we got a little something for everything so that, once you go into Express Trust, it's a whole nother world. Now you have to know how to fully live it in every aspect. So that way you feel like, oh, I'm nothing really changed. I have something for everything. And it's simple. As long as it makes sense, as long as there is a public law to back it up for any court proceeding, you can do it. And that's what we've done. So good point. Good point. Anything else before we let these people go?
Not to my knowledge. I mean, like I said, you've summed it up perfectly. We have remedies at the 0%. If any of this piques anybody's interest, come give us a visit.
Give us a visit, give us a call, 888-899-2262. Again, 888-899-2262. Give us a call. One of our receptionists will answer and take your information for any inquiry. And from there, we will schedule your Zoom call with one of us to talk about anything that you may inquire about. It can be about injunctions, it could be about setting up express trust, tax issues. It doesn't matter if you are an employee or a business owner having your own company and you want to remove taxation as well. It's all possible. Debt discharge is possible as well. There's public versions of debt discharge. I'm sure a lot of people online have heard about that. 1099s, 1099 OIDs, all that stuff, but that don't pay no attention to that. Everybody who's talking about discharge, they want to avoid court. If you can't prepare yourself to go to court, then don't even do it. And the best way to do discharge is accord and satisfaction from UCC 3-311, which has been codified in every state's charter. And we show you guys exactly how to set it up to where the banks have no choice but to render the entire obligation to zero or to give you a significant debt reduction. And that's what we're finding with a couple of our members today. Actually, I'm not going to say her name, but she just got notification on her credit report. Equifax and Experian dropped the HELOC account off her account.
Wow.
And so just waiting on TransUnion, but she has at least the biggest two right now when it comes to the credit bureaus. So she's good. She's good. I
Wow.
still want her to prepare a bill of complaint to sue the bank for the face value of the note. You never know if she can get something out of it, but the main thing is it's off her credit report.
Right.
And she avoided doing 1099s and all of that stuff. Um, it's nowadays it's a complete waste of time because they accept these things when it's in their best interest, and their best interest means balancing out the debt to where it doesn't get too out of control. But the way things are going today, we're about to convert into a whole nother monetary system. So I wouldn't even bother trying to do 1099A and 1096 forms and all of that. I would just most likely do a court of satisfaction. So we also got other remedies coming out. I'm not going to get into it in depth, but airline injunctions, very important. TSA and the whole Patriot Act, get rid of that. What else we got going on? I'm not going to spoil the beans. You'll hear. Just stay a part of the channel and see what's going on with us. But remember, 888-899-2262 if you want to talk with us. Or I will see you at patreon.com/the0%. See you guys later.